I can't believe the actual. I've just had like the most maybe the deepest revelation that I've had through this whole thing. But it's so simple. But it's the profoundness of the revelations. It's almost like in the Bible, revelations. But sometimes you read these things or say these things, and it's still, this is what professors are meant to contemplate subjects. They're meant to further the deeper understanding by through contemplation. Not only like mathematical, and you see, you can. What you're doing when you're calculating, look, right, when you've got a ruler, right, and you've got a measurement on the ruler, right, you calculating, right? Well, the majority of mathematics is like adding, subtracting, dividing. Now, it doesn't matter whether you're calculating like the distance around the planet, like Howard Crowes were talking about in his new videos, right, or whether you're calculating an angle or calculating divisions into pi, the decimal place of pi. What you're doing is you are adding more information in, because like you've got centimeters and millimeters. You can calculate more and more in between those centimeters and millimeters, and what you're doing is you're actually adding more information in there until you get down to molecules and quarks, because it's space that is not measured or written. Between 1 millimeter and 2 millimeter is a blank space, but as you zoom in, then add more information, then add more information, then add more information, then zoom in. What you're doing is you're filling it in. You are filling it in with information, right? Or if you're like zooming out and adding more context to it for what it applies to or what applies to it, you can zoom out of something and zoom outwards and outwards and add more relevant things in context. So what that thing actually, what other things apply to it from outside of itself, or what more details you've got. This is the fundamental basis of intelligence. This is why you have a professor, and he sits there and he can tell you more information about something. That's the point. Firstly, he's remembered all the information about it. And once you remembered that, you know all the information there is. And then when there's more information to learn about something, notice that professors don't always invent new things. That's an inventor. An inventor invents new things. Professors know everything that's known and learned, but then you further it. How do you further it? Well, you can't create a new thing, invent a new thing, or you can learn more about something that exists. When something exists, you aren't inventing it. When something exists, you aren't creating something. What you're doing is, if you find out more about something that already exists, it's not an invention. It's finding more details about it, more informations. This is what they're doing at this Hadron Collider, right? So it's something that we've already got, something that exists, but I want to find out more about it. Find out more things about it. You can have one word and you can, get 1,000 different things about that one word. So this is what contemplation is when you contemplate a subject, right? So I've just been, thinking about the whole, the Bill of Rights, the actual bill itself, the actual document. What is this? Well, it's the rights and liberties of the realm, and the fact that they were being subverted. But it's saying that the rights and liberties of the realm were being subverted. So that means you had to have had some rights and liberties. Now, before the 1688 Bill of Rights, we don't have, it is the right of the subjects to petition the king. But we knew they were petitioning, because of the 1661 Bill, Tumultuous Petitioning Act, which is too much petitioning. But then it's not the right to petition. But it definitely was a fundamental right. But if you don't have the right to petition, but they've got petitioning, but there's just tumultuous petitioning, too much petitioning. But it clearly was already a fundamental right of the realm. But they didn't actually have an act that says this is the right of the realm, right? But in the 1688 Bill, it says subverting the fundamental rights of the realm. But they were referring to it in the past context, right? Not in the present context. It says they were subverting, the evil judges, ministers, or councillors were subverting the fundamental rights and liberties of the realm. They were doing before. So that means that, what are these fundamental rights of the realm? Well, it tells you, the right to petition and so forth. It's creating the law and the right to petition and non-prosecutions equivalent so illegal, and illegal prosecutions by the King's Bench, right? But it refers, the act refers to as if those rights, it speaks as if we had those rights, but they were being subverted. So to protect them, they made this bill, and they're listing everything out, and this is when they add the protection and makes it illegal. So why would you have to make it illegal? Because it was being previously subverted. Although the rights, so if it says the rights were being subverted, then it means you had the rights before, in the previous time. Well, we know they were doing petitioning because of the 1661 bill. But it didn't actually announce it like, it is the right, blah, blah, blah. We had it, and then again it refers to back, going back and back. So the further and further back. So these are definitely rights that we had, or that were esteemed or known of and used, right? So now with the fundamental liberties, right? So the thing with why would you give the subjects the right to petition and all prosecutions and equipments for doing so are illegal, right? Well, the thing is, you might have standing army or not, and you might have the right to bear arms for defence or not. But with this, right, what happens, the thing is, right, what happens when suddenly everyone, right, you don't, when it once, basically, right, essentially, we've got this old Trump indictment going on now, and they're saying that, Trump was getting people to walk, peaceably, because that's what good citizens do, apparently they were going peaceably. So we don't know actually what happened with all that incident, in the White House with them. I saw the footage with them all storming inside, and some of them were armed and so forth, but there was a lot of people who were saying around there who were in and around the area who didn't even see any action like that. The police are now saying they were set up, and apparently Pelosi didn't actually call for any assistance for quite some time or something. Now, the thing is, in Parliament, this is why I've got this page up here, right? It says, watch PM's questions, debates and committees, right? Visitors are welcome to watch debates and committees hearings in both the Houses of Commons and the House of Lords. So visitors are welcome. Visitors. Now, I don't know what the security is in Parliament, because London is a security nightmare with all, the bomb scares and terrorists and so forth. Congestion charge zones, pollution, and, God knows of what other busyness and nightmares. But, funnily enough, believe it or not, after all these things, you're actually allowed in there, whether you'd want to go in there or not. I think the gallery's up above, that's why you don't really see any other people, because the cameras are all filming below, but you can go in there. That's astounding, based on the fact that 10 Downing Street has got bars on it now and so forth, after Thatcher apparently, and then, so clearly they've got security there, they're checking people for bombs, they're checking people for guns, they're checking people for weapons and so forth, but you're allowed in there. You don't really see people in there that often, but you're allowed to watch, whether or not where tourists want to go in and watch and see it, or whether you're interested in politics or not, or news reporters in there. But, most people are going about the daily business. The big smoke, the London where the streets paved with gold and blah, 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 big palace gates, and so forth. You can actually go into Parliament and watch, according to this. And from what I've heard, I don't know what the protocol is, but you can go in there. Of all places, that you could go, you can actually go in there. But the security must be super, 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 like, one of those laser beam type things. But, many people have been to court before. You know what the procedure is when you go into court, right? But this is the thing. So there is a law where you're not allowed to go into Parliament armed. You can't actually wear armour in there either, so I don't think you can wear bulletproof vests. I don't know how that works for security. That would probably mean security. It says you can't actually wear armour in there. You can't actually go in there with swords or armed with armour. I don't know how that goes with all armed police and security and so forth, but obviously if it's super tight checked for weapons, then you wouldn't need any armour, would you? I think that's the point, The only thing in there that's dangerous, I think, is that mace, which one of the ministers tried to pick up and take out, picked it up and tried to walk out with it, and he got called back. Now this is the thing, right? You actually are allowed in there to spectate. I don't know how many people you can hold or how many people you can fit in, but symbolically, surely that means that the nation could watch if you could fit them in. Physically, I don't know what the maximum capacity is. But this is the thing, right? Right, in elections, you have polling stations and ask you to vote. In petitions, someone starts a subject and gets people to support it. We know that petitioning predates electing MPs, and you could petition for them to the King to call Parliament together. And petitioning is a proper official judicial process, and it had justices involved at various stages, Lord of the Articles, magistrates of London, or whatever. It's a judicial process. In fact, if you're getting laws made and changed, there is no doubt whatsoever that it's more important than criminal proceedings or civil proceedings. Now, one third of the public don't even vote, or now I think it's a half. I think it's over half the last time I checked, or at least in the last elections that we heard. There were, like in Northern Ireland and with these by-elections, over half the people didn't turn out to vote at the polling stations. So not everyone's even interested in politics. If you could get them interested in politics, that would be something if you had 100% turn out at the voting. Now, what I think is significant is, right, with that Ian Bray case, the thing with the jury is that it's picked at random. It's not just picked at random for a reason, because it's meant to be fair. Because if it wasn't picked at random, you might be able to say, well, we'll choose some people who are with a particular side bias, right? The particular bias in one side or the other side, right? So the randomness selection of the jury is supposedly meant to be, like the luck of the draw. It's meant to be so you can't say that one side or the other. Well, we don't know how thorough that process is. But in the Ian Bray case, they completely disregarded the law. If they can make their own decision upon anything, that means that any statement that anyone makes and claims is true, even a professional witness, a professor or something, they can completely totally disregard it if they choose to. So really, if they want to, they can make their own minds up and disregard truth or even disregard the law. And after all, petition makes and changes the law. It seems that the jury can, in a case, disregard it, which seems ridiculous in that Gregory Perrin's case at Southwark Crown Court. But with look, ultimately, right, and I think this is absolutely critical, right? If suddenly the more and more people you start getting interested in a subject, in a matter, in a cause, whether it's a political party or a singular cause for one issue, one thing that needs to be addressed, redeemed, made, changed, repealed, investigated, or whatever action is required, even punishment or justice if it's misbehaved counsel or whatever. We've got monitoring officer. Complaints can be written, multiple complaints can be written, 100 complaints can be written, 100 signatures can be written, 100 statements can be given. That would be compelling, wouldn't it? So, look, when is something right or wrong is when people say it's right or wrong. Now, I think that fundamentally, with this whole, what's going on in the public with all this protesting and rioting or even, actions, banners, this and that. Well, the thing is, when is it anything to do with you? When is it your business? Well, it's your business when you make it your business, when you have whether you have an interest in it, a right or a privilege. Well, that's the thing that they've got in many of these acts, like Criminal Damage Act and so forth and so forth. When you have a right, privilege or interest. Well, when you have an interest in it. The thing is, although they select the jury randomly to ensure no bias, they have a certain set number. That doesn't stop spectators turning up in a courtroom. Like Jonathan N. Fuller has been turning up in a lot of court cases. Who even likes courts? Who even doesn't find them a bore or a chore? Some people don't want to go anywhere near a court unless you had an interest in it, newspaper reporters. So, the more and more you have an interest in it, the more and more it gravitates you towards it, and then you start to turn up. Well, you can spectate in these courts if you want to turn up in the gallery. Nothing stops the public watching. Now, the more and more interest that the public have in it, like Jonathan M. Fuller, the more and more people start to turn up and start to pile in. Now, it clearly does have a capacity in the room, but in theory, there's nothing to stop everyone turning up. Everybody, right? And that would be interesting. Now, we know that the jury is officially selected at random and, blah, blah, blah. But symbolically, what is actually going on? More and more people of the public are having an interest in this case and turning up. Now, I would suggest that, let's just take out of context the physical capacity of the room, right, and say that everyone has a right to be there. Let's go on the legal side. On the legal side, everyone has a right to go and watch. Okay? Now, the physical capacity is just a matter of physical capacity, isn't it? Full house. If you can't fit any more people in, then you can't fit them in. But, on any given day, anyone in the country has a right to be in there. Now, you could say first come, first serve. Well, the jury are asked to be there at random, right? This is the thing. Now, let's say, symbolically and in law, if anyone in the country has a right to turn up, right? But, let's say they all turned up at the same time. Let's say everyone drove, walked, flew, sailed, or whatever to Charlie Magistrates Court if it wasn't closed down at and they appeared at the exact same time. Who would have a right to be in there and not be in there, right? If it wasn't a queue with one at the front and one at the end, who would be allowed in and who wouldn't, right? Let's say if they all arrived at the same time, right? Let's say they didn't arrive in like a bank machine, a cash machine queue, right? Like a queue of people, number 1, 2, 3, 4, 5, 6 in an orderly queue. Let's say like they all arrived at the same time. So there was no way to say like, this guy was first and second and third, right? Well, what you'd have to do is you'd have to put everyone's name in a tombola and draw them out, right? You'd have to pull everyone's name in a hat, put it in a hat, and then draw them out at random and say, right, the court has got a maximum capacity of, 125 seats. So Or like on a bus, it's got capacity of 80 passengers and 17 standing or whatever, right? So that's random, innit? It's like random like the jury. Now, this is another fundamental twist on it, which is really significant, which I don't think Jonathan N. Fuller really fully could grasp or understand or contemplate. And that is, well, I'm not suggesting that he's stupid, but what I'm saying is I really don't think that he's sat there and the significance, the layers and layers of, just superficialness fall away to that fundamental eureka moment of this means something and this is an ultimate truth, which is that at a wedding, right? And remember, wedding is proceedings, and in Magna Carta, in the absence of a justice and the absence of a knight of the realm, a ordained priest can make a order and decisions. Many of the priests following Extinction Rebellion don't actually understand that is like Magna Carta. You could argue that now in court. Magna Carta has been used in cases in America, right? Even though, but we don't use that process anymore. It's like they're saying that you're meant to be able to have a jury in civil cases, but they just don't use it anymore. But GROVES has been talking about it, and many people have been saying that they've kind of stole this jury from us in civil cases, right? Well, the thing is, when you go to get divorced, you have to get legal proceedings. The ordained priest wedded them legally, and you've got legislation, therefore, that is in effect, like these belongings are the entities, therefore the married couples, and then other legal entitlements and rights and so forth, right? So he's doing law. The ordained priest is doing law, but then you get a justice to undo it because priests kind of like don't like separating people. They like to apparently bring people together. In the absence, theoretically, if you're going by the law of Magna Carta, if you want to go back that far, which is proper law, in the absence of the justice and of a knight, you could, the priest would be doing the divorce in civil proceedings, not just wedding. That is another fundamental truth. If you want to go back to proper law of England, and what the framework and basis springs from, the roots, So now the thing is, right, that in those proceedings, in the wedding, right, you do have a witness, you have witnesses, but then you've got your congregation. And the thing about the wedding is that the priest asks the congregation, and this is so important, I've mentioned this in so many videos, right, that he says, if anyone now has any reason or evidence why these two people should not be married, then they're allowed to speak now or forever hold their peace. Speak now, which means you can speak, you may speak, you have a right to speak, and then after the words have passed your lips and been spoken and said, everyone heard them and witnessed it, then you may ever hold your peace, or if you don't want to speak, then you can hold your peace, and then you don't say anything after, but you can say it now. You might even get kicked out of the congregation. They might even remove you, or God knows what. But he says, you've got a right to speak. It may pass your lips. I think that's very important, like if you're in a private house, because in a private house, we're meant to have free speech everywhere. You have the right to talk, the right to speak. Now, you could be friends with someone, or you could be in a party talking. Now, if that person, the owner of the house, asks you to leave their property, then you can leave, or else you're trespassing or whatever, unless it's medical or emergency or whatever, people need treatment and so forth. But it's all that ownership, leave. But, you are free. They're trying to do this, these oligarchs and on the platforms, they're trying to stop you from speaking in the first place, but you have to be able to speak in order for them to get a reaction to say, I don't like that, and I want you to leave, So, you have got free speech, in the majority of things. In the private house, this is what Neil Mohan's trying to do on YouTube, right? He's trying to say that you don't have the right to free speech, but effectively, everyone's got the right to free speech because you've got to say something in order for someone to say I don't like it, or in order to say everyone, you're banned or whatever. Now, but going back to the congregation, right? So it can pass your lips. It can be said. People's ears are there. They'll hear it, and then the knowledge will be transferred, right? And then the knowledge will have. Everyone will witness it, and that will have effect, whatever effect it will have on opinions, or regardless of what the priest says or doesn't say. It's the fact that he's asking for it to come out. If he's asking for it to the information to flow, right? And whether he will use a judicial power, which he's using the judicial power to wed them in law, right? Whether he will make a decision not to wed them on that, but then everyone will hear it. So, the bride or groom themselves, if there's something that they each didn't know, then they might decide that they might not want to get married. One of them might walk off. So notice that, you see, in civil proceedings, right, it's party A versus party B. Party A versus party B. Right? So claimant and respondent, plaintiff and respondent in a civil case versus, right, you owe me some money, you will pay me, or this is my land, you don't own it, or this is my company shares, or this or that, or policy breach, or whatever. You've got a claimant and a respondent, a plaintiff, respondent, right? Now, in the wedding, notice there's something a little bit different. It's not verses. It's not like, they're actually, party A is the bride and party B is the groom, or whichever. And notice they come together to join. It's a civil proceeding of union, not like in a civil case normally. Versus. When you are getting divorced, you are getting split up. Now, one person might want to get divorced or the other, right? And like I said, supposedly in old England, traditional England, you've got this, absence of justice or knight, then ordained priest has powers. Now, going back to the church, so it matters what the people think, and they're congregated there also, but it's all meant to be people who have an interest in the wedding. But remember, weddings and so forth can be announced in newspapers and published, weddings, university graduations, obituaries, blah, blah, blah. You get invited to a wedding, there's an invite, you get an invite. I'm not sure about if anyone's got a right to be in there, but I would suggest I'll have to read up on this, but doesn't it suggest that if he's asking everyone, to speak now or forever hold their peace, then surely, anyone who would have anything to say, which could be someone who might not necessarily have been invited, right? So that gives a suggestion that, like the courtroom, in the proceedings in the courtroom, if you want to turn up and watch in the gallery like Jonathan M. Fuller, if you had a reason, then you could turn up, even if you weren't invited necessarily. You weren't invited usually if it's fans or friends or family, because they want you there to enjoy it. You say you can't be there, now. So with these old courts that Jonathan N. Fuller. And the name seems more and more significant the more and more I think about it. You're turning up to watch at these court sessions. Now, there may be a jury in there, or there may not be a jury. If it's a magistrate's court, there won't be a jury. I don't know at Crown Court if you can watch or not. I'm not sure because you've got jury in there anyway, but the Crown Court's a lot more high security and a lot more posher. I don't know where the gallery would be. I'm not too sure if they've got one like with a glass case or not. I'm not sure if you can watch it or not if you want to. I'll have to look in that, but they definitely do it in the magistrates' court and the county court and so forth. But the thing is, this whole public spectators and gallery, most people haven't got an interest in going to court. We need to try and get some people to turn up, right? So we better select them at random, right? So it's, supposedly, so it's fair. Now, when more and more people have an interest in it, you've got more and more people turning up. Now, anyone could have an interest in it who was opposed to it or for it. Usually you've got Jonathan M. Fuller turning up because, he supports the campaigners, but you could have these people who don't like Just Stop Oil or Extinction Rebellion turning up because they really don't like them and they want to see them convicted, theoretically, if they've got an interest in it. So you could potentially have people on both sides who might turn up, It doesn't have to be one or the other. If they've got an interest in getting them convicted, this is the thing of free will. So, now, I know you've got this whole contempt of court thing, but that's meant to be disruption, obstructing proceedings or, insulting, persons or the judge or whatever. Contempt of court, it's almost like that elections intervention, intervention in the democratic process is illegal. Election intervention, 5013C, illegal campaign intervention. Well, it's meant to be illegal to intervene in political campaigns. Now, isn't that a little bit like being in court and being in contempt of court because you're intervening in proceedings or disrupting them or insulting the judge or breaking the law in some other way, right? But what happens if you're in a courtroom spectating legally? You weren't intervening in proceedings, trying to destroy them, disrupt them, attack anyone. You weren't armed with weapons like in Parliament. You're not armed. They've got security at the doors anyway to check you, right? But let's say that you had some, information, critical information, important information. I'm starting to wonder if you can speak. Well, they can't stop you speaking. That's the thing. Now, the thing is, no matter what consequences you may suffer, you might end up getting arrested yourself. You might be if they wanted to charge you with contempt of court, but they might not. Theoretically, this is going on to theory now. Like at the wedding situation, there's not, if you knew something about law, or if you know a right or a clause of law that's been overlooked, and this is truth or fact, like, should there be any reason now why, this right should be applied, or if this law's been contravened, regardless of statements or evidence or other facts or whatever, they can't actually, unless they put a gag around your mouth, they can't actually stop you speaking and shouting out like Tourette's, like Tourette's. You could say, Your Honour, I object. The rights are clearly stated in clause 3.1c that this shall not be done. Everyone heard it. They all heard it. Now, it doesn't matter whether the judge says, order, slams his finger down and gets a security guard to come over. He couldn't stop you from saying it in the first place, so he heard it, and everyone heard it. And that's the thing about court. The witnesses. Did you witness it, and did you hear it? And that's almost like at the wedding. Now, speak now or forever hold your peace. Well, you might have to forever hold your peace if the judge says you're in contempt from court. You might have more than forever hold your peace. You might end up, being charged. Although you might not be charged, but he might have you removed. But you spoke it. You said it. You've got the opportunity to when you're there witnessing. Now, really, is there in the law a certain moment for things to be said or heard or so forth? Now, the thing is, on that basis, right, on the basis of Parliament, let's move to Parliament now with all this in mind, right, you get checked for weapons and armour, you're not armed, and you haven't got a bulletproof vest on, but you haven't got a gun either, no one's got a knife in there or anything, right, and you're in the gallery, everyone thinks we better behave or we might get into trouble or whatever, but in the spectators of Parliament, in front of the whole world, in front of the whole country even, in theory, It could be the same. Well, it is the same principle. You can, you've got that God-given right, that biological right. You haven't got a face mask on. You haven't got like a Hannibal Lecter thing on you stopping you from speaking. You can talk, and nothing can stop you shouting something if it's a fact or truth. There's some very strange behaviour of MPs. Some MPs behave very oddly in Parliament. I saw a woman, she looked like she had some kind of disorder. She was like standing up, then sitting down, and standing up, then sitting down. It was kind of like exciting, and she was using this eccentricness that some of them use. They express it sometimes, stand up, sit down, stand up, sit down, kind of like naughty school children. Sometimes they behave like Andrew Bridgen, very normally, but other times they do that, but there's a certain yay, there's a bit of a yay and nay to it. Yay, nay. It kind of comes in with all that yay, nayness. It plays on the fact that they're immune, they've got immunity, and they can be naughty, but this constant order. So it's a kind of artistic expression of the fact that they can do what they want and misbehave while behaving. That's how I'd explain it to John Bercow, if I had to explain it. Now, the other interesting thing is you can shout out, yay, nay, or whatever you want in Parliament, and people will hear it if you're loud enough, and it will register in their brains before he removes you. Now, the Speaker can ban MPs from Parliament, but you notice they don't get prosecuted. They're just banned by their party or by him for so much time for misbehaving, being naughty. Now, if you think theoretically the jury, the spectators surely under the right to petition government without prosecution and so forth, it's the right of the subject to petition the king or either powers of Parliament, and all prosecutions and commitments for doing so are illegal. So how could you be prosecuted for shouting out in Parliament? You might get removed by the Speaker, might throw you out, but only as much as that guy who picked up the mace and walked it out with the power of Parliament, and then someone blocked his way and called him out. It's like, Sir Jack. Hello, Sir Jack. You've got a big smile on your face with your twinkly moustache. This is it. Now, you could shout out something fundamentally important in Parliament, and they might hear you, and then halfway through the debate, they might all click. Like it might just go. They might just click like that. Now, the interesting thing is, who would turn up in Parliament? Who would show up? Who would even be interested in it other than tourists passing through or someone who wanted to watch a particular debate, a newspaper reporter or whatsoever? So therefore, again, I go back to that fundamental model that I set forth at Chorley Magistrates Court with the theory, which is everyone has a right to be in Parliament and watch, therefore, of course, anyone can go. Theoretically, anyone has that. If you've got the legal right, then in theory, on basis, everyone can be there because they've got a legal right to. There's no one who hasn't got a right to be there. But physically, how many can it hold or who could get in there? Well, depends who arrives first. But then again, what if they all turn up at the same time? Or there's people on a certain naughty lists, But fundamentally, who, John Bercow was banned from Parliament. But people who haven't been banned, if you had them all turn up at the same time, you'd have to, put you could theoretically say, we'll put their names in a tombola hat and draw out names like that petitions bag. You could say the petitions bag that hangs behind the Speaker, put everyone's name in there who turned up and pull them all out, and then that 200 whatever many people it takes in the gallery, that's who there's going to be. You could put everyone in England's name in the Speaker's chair bag, everyone's name in England in the Speaker's chair bag, symbolically hangs there, and draw what's the maximum capacity of Parliament. If everyone wanted to be there, you theoretically would have to draw out, say it's got 300 seats, I don't know how many they are, but then you'd have to draw them out just if they all arrived at the doors at the exact same time. You could theoretically say, well, we'll have to draw hats, draw them randomly. Draw names out of the hat randomly, right? So that's what you're doing there. That's jury. It's effectively the same as a jury. Now, the thing is, in a court case, right, they ask the jury at the end. they ask the jury, have you achieved a verdict, right? That's when, jury have to be there. They choose the jury. Now, the thing is, right, now, what happens when people suddenly start getting interested in something and they want to be there? Well, if they suddenly start getting interested and want to be there, you can't stop them from being there if they've got a right to be there. And this is when you're gathering interest. The interest is increasing and gaining more and more gravity. And as the interest increases, more and more people gather and more become interested until the interest is so immense. Now, what happens when, therefore, you have got the interest of the entire country? Let's say, for example, all 60 million or whatever people theoretically were registered voters in England. Let's say they all did have the interest, and let's all say they all turned up at Parliament, and let's all say they all had an opinion, and let's say, that opinion was 51%. And this is the thing. When the entire nation has an opinion on something and it's 51%, we know that it cannot be beaten in a ballot box or any other system of voting. Because if it's in any kind of vote, if it goes to a vote in any way, the majority will win, whether it's elections, petitions, referendums, whatever. And everyone has a right to be there in Parliament. And really, you couldn't stop people from shouting out, at least the first initial thing. So this is theoretical science. So with that fundamental concept and model, which is a legal model, that everyone had a right to be in there, and everyone, if the interest was so immense that everyone did want to be there present, and if everyone, didn't want to, if everyone wanted to speak now, and then forever hold their peace after and be asked to leave, they with that one voice they've got, they shout out the yay or nay, in favour or not. That's what they do in Parliament. They count. So they count how many people, they count them while they're there. They count how many MPs in favour and not. So if they count every single person in England at that moment, they shout out, even if they say order, order, order. You could say order, 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 and then tell them all to leave. But that's the amazing thing. Once you shout it out, the number is being voiced. It is being cast. And that's it. It's done. So really, it is now, when you start looking at the right to petition, and there's more and more people getting interested in these cases, then you really have a working model for the ultimate grand jury's opinion. And really, you can't prosecute them for that shout in Parliament, because it's the right of the subject to petition the King and all prosecutions and incumbents for doing so are illegal. You can't. You can ask them to leave. Now, are they in contempt of Parliament? They might be out of order. Order, get into order. Oh, I'm sorry, Mr. Speaker, we will get in order. Can you ask us to cast our votes now? Are you ready, sir? Because their intent is to voice their opinion. Why did they speak? Why did they shout out? We spoke to tell you our opinion. Count it. They wanted to assist. They wanted to inform. They wanted to give their petition their number count in the petitions bag. They didn't do it to throw the case, pull down the building, halt proceedings, stop. They added to it. They had some urgent, important thing to add. They were assisting. And the same could say for the magistrates court or even Crown Court or whatever, like when the Jonathan and Fuller's there. If you have something to say, like, if it's important in your mind and head, and that these people need to know this, you're not in contempt. You're actually helping, assisting, hue and cry. Hue and cry. You see there's something wrong, there's some law or something or fact or point, and you shout out, hue and cry. So there is immunity from being prosecuted for that. And why would they be there? Because they had a right, privilege, or interest in it. Suddenly, who has the right or privilege in these petitions? Someone who has an interest in it or wants to join in. So, what immunity have they got? Well, what immunities have the MPs got in there? I'm a subject to the realm. I'm in Parliament. I've got an interest and privilege and right to be in there. This is it, whether you get removed or not. You're not armed. You can't have armour in there or weapons in there. And I don't think anyone is actually, all of these Extinction Rebellion protests, from all the laws that Sunak's enacted and changed, none of them have been charged with having or carrying a weapon, I don't think. They've been making some orders like you cannot carry paint or be here or there in this place or that place. But now we've found out that, painting something's not actually that bad because, if it definitely is for the petition to advertise it, it's under Class C advertisements with use of the enactment, and it's already set out through 2 acts of law, which Max Hill didn't choose to engage in. So, on that basis, I think you could possibly apply this to the Trump case, possibly. Although they went in there with weapons. I don't know if Congress has got that. They've got the right to bear arms, but I don't know if they've got like a particular law that you're not allowed to go in there with weapons. Like in Parliament, you can't go in there with weapons. So, if that Congress event had been Parliament, they broke that law that you're not allowed to go in there with armed, is illegal. Although you're not allowed in there with, I don't know if you can be prosecuted or not, you're not allowed in there with weapons. I don't know whether you'd suffer prosecution for it or not. Possibly, I think it probably says in that law that it's illegal. And actually, in the 1688 bill, you can only bear arms for defence, but in Parliament, you can't even have armour. You can't have defence in there because you're not really being charged. You're debating the country or asking for an inquiry or whatever. I think they did have judicial powers in there, though. Maybe you could have been charged, but they took them away, didn't they? In the Lords, you can. They've got judicial authority. Maybe you can be charged. You could have been charged by Parliament. But could you have been charged for petitioning as part of the case? This is the thing, what constitutes as petitioning or not. Advertising something. This is the thing. There was some misbehaviour of Extinction Rebellion in there. But, so the fundamental basis of this is, so when you think to the fact that everyone couldn't fit in Parliament, that draw the names out of a hat and see who can fit in there. Ultimately, that is what you're doing with the process of a jury. But mainly, people aren't interested in these cases. They've got to try and get some people, try and make people turn up, so they'll draw them at random, There's a working model there. It might not be conventional or to what the modern... This is when you've got to challenge the CPS. Oh, this is how we do it. It's policy. There's a hell of a lot of things they're doing in these company policies now with these big oligarchs and platforms and enterprises and so forth that we're questioning whether they're against rights or not. The whole thing that civil proceedings should and could have jury. The CPS, oh, I did it my way. The CPS like to do things their way, have their little order. But many of the times, if you're in courts, things aren't being done properly. They're leaving things out, not doing things properly, not applying overriding objectives. Many things. Max Hill ignoring 2 entire acts of law on purpose because he wants to undermine and subvert the fundamental liberties and rights of England, and get convictions out of it because he's a criminal. This is it. So if you get the fact that everyone really has a right to be there and an interest in it, and you couldn't stop them speaking or shouting out, you can't actually physically fit them all in the building. They'd have to be outside. They'd have to be outside the building, gathered around, congregating. The congregation would be around. This is like a deeper meaning of a congregation. And this is why the right to petition was enacted, because people were congregating in public about these petitions here and there, or having private meetings, discussing them and debating them in order to set out their terms or discuss what is true and what is not true in order to get it in, try the information with Parliament or with the courts or whatever. It's trying information. first thing we have to understand about these things is its proceedings. The second, it's a judicial proceeding. The second thing to remember is everyone has a right to have an interest in it, and has a privilege of that right. And another thing is it's not always physically possible to fit people in the building. In fact, in some of the objections in Murfield, when they were trying to stop that Incora place that got there, Incora airplane engine place or airplane parts place, when all the public were objecting against it on multiple occasions, when they objected like twice and won and the objections, the council arranged it in a very small room and not everyone could get in there and hear what was going on or happening. They outfoxed them. It was a con, a trick. When they knew that there was a lot of people interested in that, they should have arranged a bigger meeting room. Ultimately, the people of Murfield lost, and the business of the chamber, the business of the council won. It got knocked back so far, and then the council really, really wanted it with their Labour Party investors who were obsessed with getting this industrial estate built, regardless of what the public opinion was. And then Cheryl Tyler, had won an award from the council, which meant nothing after all her attempts to stop houses. But then, the village still gets ruined by these corporate entities who have just so much financial and lawyer power that even, Mark Kerr, HS2, even winning court cases himself can't stop them. Their lawyers just come back with, like Trump's lawyers, with infinite funding, like an springback coil. You just don't have and everyone's engaged in employment all day, and then you come home and want to spend time with your family. You just don't have the time. And then they take time off you by watching their adverts and, on YouTube in between videos. It's strategically planned, so you will not have even if you have a privilege, right, and interest, you might not have any time for it or any finances for it because they're not paying you any money. So they'll just defeat you. This is it. But when people do get an interest, or you can get them interested. So everyone couldn't fit in the building anyway, even if they wanted to be in there. But if they wanted to be in there and they could be in there, then they'd all have the same rights. Now you might say, well, these are elected MPs. Well, we're meant to elect the MPs on our behalf. We channel our powers into them because they are meant to represent our local interests in the surgery, although they're affiliated with political parties. That's the only problem now. But ultimately, they're meant to be representing us if they were all independents. Now, when the people who didn't vote for them, but they want something in Parliament, start coming together, it's like Partygate. You are forming a party almost for one particular cause, one law, one motion, one inquiry, one thing. And it can severely outweigh the amount of powers that MP got themselves to be voted. Now, if you get that in Parliament, you are quickly outweighing the entirety of the powers that got them all elected. Because if every single person in England turned up who was registered voter in Parliament, you've immediately got more voting power than the totality of the entire congregation of MPs got elected to be there in the first place. And if all started shouting out yay or nay, he may well shout out order and throw a few out. But surely, then again, if there's only room for 80 people capacity and he's throwing them out, then, you fill it back in with people who haven't yet been thrown out. You could have a turnstile going round, until everyone in England's been through there and thrown out. Could you ban the entire country from Parliament? Would that be proroguing it? Possibly. Ask John Bercow if everyone in England would be barred from Parliament except the MPs. Would that mean they're not allowed to watch it on the video link, or they're only barred from there in person? Is John Bercow allowed to watch it on a video link? But symbolically, there is something to that, because you might say MPs make the decisions, the Speaker, the Prime Minister, but who compels them to? And this is the thing why the police and the royals and everyone, they've got to make it look like, only certain people support parties, or look like only certain people support this cause. This is why we think that a lot of the petitions are being hacked, or signatures are on there, because, you know, if it looks like people don't support the cause, then there's nothing you can do about it, no matter how compelling the evidence is. When you can visibly see, you know, a lot of people support it, then they can't ignore it, which is why they don't like publishing things on the Parliament website that they don't really want people to support, or none of the parties like, or it might be affecting the reputation of any MPs or anyone else. You know, even though theoretically, you know, if an MP can initiate an inquiry, then an MP can telephone the police over any matter, or the High Sheriff, the Lord Advocate. Really, you know, the Lord Advocate surely has a place in the Privy Council. Being Lord Advocate, surely they have powers to direct the Crown Prosecution Service with the Attorney General as well. Believe it or not, you can petition for the Lord Advocate to do that. Martin Day MP, you know, they're so set in their current, this is how we're going to do it. It's not policy. They really don't actually understand they don't fully comprehend what it actually is, what they're doing. They're kind of like these staff who have got these rules and they're being told what to do, and it's all proper and prim and order. They don't really actually understand the fundamental deep truth of, if everyone in England did turn up, what are you going to do? You know, and what are you going to do when every person in England draws a pen or shouts, cries, screams that one word, yay or nay? Yay or nay. Count the yeas and ignore the yeas. That means the vote has been cast. That means the opinion has been made and the voice has been heard. Speak now or forever hold your peace. It's not possible for the Parliament of England to ignore or deny the 51% majority, and they have the right to turn up in Parliament in the gallery and cast it. The fact that before you get thrown out, you're not actually in contempt, because you might be out of order, but being out of order is not necessarily being in contempt. And if your intentions are to pass critical information that is of the utmost importance, you cannot be in a contempt. You might be out of an order, and that could be put back in order. But in theory, they actually can't stop everyone turning up and casting the vote, which effectively is signing the petition, and the bag is hung on the back, and the voices can be spoke. It's not fickle, that model of that congregation with the church. Everyone goes, oh no, that's just church proceedings, that's just church. It's not actually. In the right to petition, subverting the fundamental rights and liberties of the realm, the right to free speech, that free speech is the right to cast your vote. And if you can't be prosecuted or held to any commitments for it, then you really can't be put in order for it or held in contempt. If at that moment when you speak is to cast that opinion, that vote, even if you haven't been selected for the jury, you see, the ironic thing about it is you've got the right to go in there and be there. And like I said, in the voluntary, it's the model. It's the fact that if everyone has the legal right to be there, who can they say can't be there? Unless you're being specifically banned like Burkow, it's down to physical capacity who they can fit in. And like I said, on the basis of, let's say that everyone turned up together, which could happen, you know, although let's say it was a very, very long line and they were all sideways, not in a queue, you know, you'd have to say, right, we'll have to choose people at random or whatever, which you're actually compelling a jury to be chosen to enter the building, but fill it up, not just 12, right? And then what happens if the 12 jurors go out and they're called to make a decision, they come back in and the entire courtroom's full of people who are shouting in opposition to it? But then you might say, well, what happens if those people who have got in there are all in favour like it's in rebellion? Well, maybe no one had any interest to turn up from the builders bumcrack crew who were opposed to Just Stop Oil. But then again, if we go to the basis that they all got pulled out of a random tombola hat and it's full to capacity, and the judge knew they were all randomly chosen, and, he asked the jury, and then everyone in the gallery says, boo, 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 what is the judge actually going to do at that stage? Now, I know there were court proceedings for choosing juries and stuff off, but they haven't been doing that with the civil cases. They're saying that in a civil case, that you can have a jury, but they don't use them. But they're meant to have the framework for it, but it's not used, right? So there is something behind this. Now, therefore, when you've got this outside of the building because it's full to capacity business, then you've got people, knocking around outside who've got an interest in it, or they were trying to get in. And if they have made it their interest, I've made it my interest, then surely they've got equal rights than everyone in the building to outside it, which is when you get these people on the streets who are supporting a cause, trying to get more people interested in the cause, advertising the cause, promoting the cause, or voting the cause, or voicing it. And that's it, and it clearly stated in that Karen Bowie paper that, the public tried to, get rid of these rights, but the Parliament were in favour of keeping them. So on that basis, I go back to Robert RFK and say, this whole rights on YouTube, and so, the thing with this truth versus falsity, trying information, it's proceedings. Whether you're in or out of the building, it's proceedings. And the thing is that in a case, you're trying the information, statements are taken, we don't know if they're truth or false or lies or not. The police don't know in the interview room. The police interview room, might as well be, when you submit the papers, the affidavit, and the judge decides whether he's going to hear it or not. But the fact is, any statement can be completely falsified and made up. Professional witnesses, might not be correct, or they might be correct, but anything can be disregarded by the jury, whether it's professional witness, statement, or whatever. You're trying the information. That's why you're gathered, so they decide. Now, with the petition, the thing when you're gathering, you're promoting it at that stage, the proceedings, the decision-making hasn't been made yet. It is an official, legitimate form of proceedings, and a lot of it takes part outside of the building, and you're trying the information, and that's what I don't think Neil Moran quite understands, that someone could use his building or facility, YouTube, as these proceedings. The newspaper, why? Because on Parliament, share this petition, you have to gather evidence of public concern. You have to ask you find out who's concerned in it. And the thing is, what are you asking them? If they're concerned about, you have to tell them. So you have to tell them something about it. Well, we want to ban water slides. Why? What's wrong with them? Well, I have to tell you that on YouTube. And it could be gory. Something happened. This is it. It's for proceedings. There were gory things in courts. People got shot. There were photographs of people getting shot. People copy things, fingerprints. That's copyright. This is what I don't think RFK quite understands. What fingerprints, photocopying photos of paintings. There was a painting stolen from the gallery or from a private house. What does it look like? Well, I'll describe it. Or I'll show you a photograph of it. Oh, look, it's Black Belt Barrister and Alan. Hello, I've taken a photograph of a painting. Oh, you can't do that. That's copyright. You don't really have the right to photograph a painting, actually, really, fundamentally. It's for personal use. Well, there's 2 copies there. Well, it's been stolen, though, the painting, and we're going to see if anyone's seen it in the village. We're going to put it in the newspaper. So they're going to print, 20,000 copies of it. Ah, right. Well, let's see. I'll debate this. It's the night lawyer. I'll do my night lawyer skills. Well, that's defamation. That's copyright. No, actually, it's for proceedings. Now, are we going to argue? Do you have to get permission from the judge to put it in the newspaper? Usually not. This is it. Or someone's, the person who had the painting stolen is going to sue you for copyright. You can't use my picture of my painting in the newspaper to ask for witnesses. But it was stolen. So you want it back? This is the irony. It's protected. It's proceedings. All prosecutions are illegal. It's a legal proceeding. If you want to start challenging the police for taking your fingerprints, some people have tried to stop them, but can Trump stop them taking his photograph and say that's copyright? I'd like to see Donald Trump tell them that he can't have his photographs taken because it's copyright and he doesn't give permission. Well, it's proceedings. Is Trump going to say to Neil Mohan, no one can upload any videos of me at all whatsoever? Well, they've got a right to privilege your interest. This is it. What happens if apparently Neil Mohan can conjure up any policy he wants as long, anything that's, all these certain things are illegal, so he can't have them on even if he wanted to because it's illegal anyway. But then he wants to go further than that. He wants to make his own rules up, like, no Morris dancing on YouTube. That's a new thing. No photos of Donald Trump on YouTube. There's a new policy. No photos of Donald Trump on YouTube. Theoretically, it's a private website. We can do that. Can you? What? Even if it's in the interest of the public and so forth. I doubt they could make a policy up. It's a private website. No photos of Donald Trump. But he's a politician. When you've left the law, this is not law anymore. This is just YouTube policy. We're just making his own shit up now. Well, I'd like to see you try. So therefore, when it comes down to the right to petition, and you've got a petitioning channel, you want to have, photos of, ban certain sexual positions or whatever, make it illegal. Can Neil Mohan stop you from doing it, from kissing on there or whatever? I doubt it, because fundamentally it's something that, if there's not a law stopping us from doing it, like, it's illegal, we're talking about things that aren't illegal, but Neil Mohan just wants to stop you doing them. But he can't. Particularly, I'd say, when it's for petition, political matters, because that's why the right's there. It says that YouTube doesn't have the right to stop you. Congress shall make no law to stop you. And if Congress can't make a law, how can someone make a house rule or policy? Ultimately, it's kind of almost like, they can't really stop you speaking. All they can do is punish you for speaking after. And YouTube want to punish people by throwing them off for saying things they don't like. So you can upload photos of Donald Trump, but YouTube will just take them all down again. But people have an interest in these stories. It's like the news. Why are the news doing these stories and telling us about these accidents? We don't really want to hear about them. Why don't we have a new policy say we don't want any of these news stories on there? Gory, a house got knocked down, someone got hit by a car. We don't want to hear about it. Well, the press will say, it's freedom of the press. People have got a right to know. I'd like to start Mohan really trying to see how far he can pull his policies if he starts to tell Fox News that they can't tell anyone any stories about anything dangerous or gory that happened or occurred because it will upset people. And then the press will start going, First Amendment, freedom of the press. You can't do that, YouTube. You can't do that, freedom of the press. And free speech is a fundamental right. I'd like to see Mohan say that we're not having any stories from any news places that have got things that people don't want to hear. They said they don't want to hear about these accidents and crashes and so forth. I'd like to see how Mohan stands up against Fox News for that. So on that basis, I don't think that he's got the right to stop people if they're engaged in political democratic process to take the stuff down. He can't. That law is that he doesn't have the right to do it. It's the same as like a private building. If YouTube own their own building, They don't have the right to do what they want with that building unless they get planning permission authorised by the government. Or I don't know what the planning rules are like in America, but in England they don't. Just because it's your building, you can't do what you want with it. And YouTube, we will comply with all federal and state law, which means they're complying with the right to petition and the First Amendment. They're complying with it. Now, you argue about what that covers and what that doesn't cover. RFK is trying to claim that, it doesn't cover defamation or falsities. Look, whether it's true or not is decided, it's proceedings, and it will be decided by the people or by the MPs or I don't really, there's some aspects of it that it doesn't quite see the dynamics of it. It's not, when it's not proceedings, whether it's in public, we're talking about, you're trying the information in a proceeding that's official, and someone somewhere is going to decide on it when you've put the information there to be looked at. If they're not, and Neil Mohan and YouTube legal team is not the judicial authority who are authorised by who the people have voted and elected for to make that decision. And by God, they will look at it themselves and decide whether they think that it's true or false before Parliament will cast a vote on it. And if they're not happy with that, then they will, by God, have a referendum on it. And if they're going to have a referendum on it, they will need to know what the information is, which was voiced, which was questioned whether it's true or not. So on that final basis, if it goes past the chamber to referendum, then how are they not going to publish it then, so we can't hear or see it in order to cast a referendum vote on it? I would like to put that question finally to Paul Groves of YouTube Legal Director.